What changes are being made to the teaching of sex and relationship education in primary and secondary schools? What school policy should be in place, and should schools consult with parents in writing about these policies? Do you have a right to withdraw your child if you're not happy about your child attending these classes, the resources used, or the external visitor delivering these topics? And what are the consequences if you do withdraw your child without the school's consent? This is a community legal education presentation. My name's Nasir Hafizi, I'm a solicitor, and here's 8 questions answered about the changes being proposed to the teaching of SRE in schools, Part 2. The focus on this presentation is on the school's duties and the limits on parents' rights. Make sure you've watched Part 1 in the series. The short answer is yes. The school should consult with parents in developing lessons, teaching resources to be used, and the criteria of using external visitors to teach these subjects. The draft guidance explains that all schools must have in place a written policy for relationship education and relationship and sex education, and goes on to explain that schools must consult parents in developing and reviewing their policy. Schools should ensure that their policy meets the needs of pupils and parents and reflects the community they serve. And schools must have an up-to-date policy which is made available to parents and others. Schools must provide a copy of the policy free of charge to anyone who asks for one, and should publish the policy on the school's website. The draft guidance says that typical policies are likely to include sections covering details of content, schemes of work when each topic is taught, taking account of the age of pupils, who delivers either relationship education or RSE, how the policy has been produced and how it will be kept under review, in both cases working with parents, how delivery of the content will be made accessible to all pupils, explanation of a right to withdraw, and who approves the policy. In short, yes, the school should take account of the religious background of its pupils. The draft guidance states this: in all schools, when teaching these subjects, the religious background of all pupils must be taken into account when planning teaching, so that sensitive topics that need to be taught are appropriately handled. Schools must ensure they comply with the relevant provisions of the Equality Act 2010, under which religion or belief are protected characteristics. The answer is no. The government have said this in the consultation document as follows: as we have previously stated, children cannot be withdrawn from relationship education at primary or secondary, as this covers content all pupils should know to keep themselves safe and happy. The draft statutory guidance says this: head teachers will automatically grant a request to withdraw a pupil from any sex education delivered in primary schools other than as part of their science curriculum. The draft guidance is a little confusing in this part, but in short it is this: a parent or carer does not have a right to withdraw their child from relationship education lessons. Concerning sex education within relationship and sex education lessons, a parent and carer has a right to request withdrawal from lessons concerning all or part of sex education lessons from the head teacher. The head teacher has the discretion to allow or disallow the request for withdrawal in sex education lessons. If the withdrawal has been accepted, this lasts until 3 terms before the child turns 16, after which the child can opt in to sex education lessons. This is unclear from the guidance. It could include a meeting arranged for the parent and carer to attend a school meeting, or it could include a meeting arranged for the parent and carer to attend with a local authority officer with a prevent portfolio. Other sanctions could follow. So it's important for any school policy to spell out clearly the consequences for parents and carers withdrawing their child without the school's consent, and what sanctions follow. If the school fails to follow the statutory guidance, or a parent or a carer is unhappy with the teaching of the subjects or lessons, or your request for withdrawal has been refused, you could make a complaint to the school or make a complaint to Ofsted. Whilst the draft guidance is yet to be finalised and is a little confusing and unclear in parts, it's important for primary and secondary schools and parents and carers to know their respective legal rights and responsibilities over children. Where there are issues of differences, it's hoped that these can be resolved through understanding and communication without recourse to complaint or public protest. However, where the issues of differences remain, then as noted by the government, parents are the primary educators of their children, and the legal concept of parental responsibility and decision making should, according to many commentators, be upheld and respected, even if this clashes with the statutory guidance issued by the government. Thank you for watching. Please speak to an education consultant if you need support. Please subscribe to Commuter Legal Education so you can watch more videos in the series and many more. Please speak to a solicitor if you need legal advice. And may the justice be with you.